there's a lot of confusion, a lot of jargons being spoken about. The idea of this session is not to throw a book at you, but to just give a feeler of the new regime of data privacy and protection that is coming up in the country. But before that, what is more important possibly is that what is there today in the country as a law on data privacy and protection. So the idea of this session would be to run you through what we have today as a law and what is coming up as our future law on data privacy and protection. Before we begin, I think the most critical phrase is the phrase data privacy and protection. There's a lot of confusion in the minds of people with these two words. You would find legislations which are interchangeably using them. You would find books, etc., all of these. So let's break this up into simple terms, try and understand on a standalone basis what do these words mean. In a very simple term, if you have a glass panel, a window or a glass door, and if you can see from the window into this room, it's a breach of your privacy. However, if you can break into this room, that will be breach of your protection. Just keep that in mind whilst we go ahead with this presentation. Now, what will be the route map of this particular presentation? We would first talk about jargon such as privacy by design, but in absolute simple terms. We will take you through what organizations have as important data that they need to safeguard. We'll talk about the present legal framework in the country. We'll talk a bit more about the personal data protection bill that is in the making. We would talk about certain quick attention or select best practices, and of course, very happy to take questions, online, offline. We are always available for that. Let's talk about privacy by design. Without getting into too much jargon, if you would have walked into a restaurant, you had your food, and you were given the point of sale machine, you would see sometimes those machines would come with a cover, and some would not come with a cover. So the guy who thought of a point of sale machine with a cover kept privacy in the center of things, and that's all that you have to do. Because whether you're developing a product, whether you're developing a service, if you're keeping privacy in the center of things, your life is that much more easier in implementing privacy related legislation. Let me give you simple examples to make you realize how we inadvertently breach privacy. New joinee comes to the organization, HR sends email to everyone welcoming the individual, maybe attaching the CV which has blood group, address, phone number, so on and so forth. Is it really required for the entire organization or the entire team to know? The answer is no. Recently, I was walking into a hotel, and there was a quick check-in counter which was in the middle of the portico, and I could face the laptop, and below the screen of the laptop, someone had pasted the password of the laptop in a post-it and kept it there. Do you think that the organization did not take enough tech measures? Maybe yes, they have taken all the tech measures. But what they did not do, possibly, is that train the individual, the last person on the ground, how to deal with privacy, and that's what is critical today. The idea behind this video also is that each one of you become the mask bearer of privacy. Go back and start educating people that you know in every sense, so that we build in the culture of privacy. Again, that would make the implementation of this law quite easy. Coming to the next important point that I was making, which is the kinds of data that an organization would have. Ordinarily, the largest set would be confidential data, which may or may not contain any personal or sensitive personal data. Now, this can be largely managed contractually. There could be some laws around it on intellectual property, etc. The second bucket is personal information. Now, as far as today's law goes, on a sector-neutral basis, for personal information, consent is king. So you need to ensure how consent is being taken. And I'm telling you, the thumb rule from now onward should be no pre-ticked boxes, no silence is consent. There has to be a positive action in order to take consent. If you implement this, whether it is outward looking, like towards your customers, or inward looking for your employees, etc., I think you are quite sorted. The third bucket is sensitive personal data. Consider it this way as per present law, that there are two pillars. One pillar is proper informed consent, and the second pillar is even after taking consent, you need to safeguard this data in a particular manner. So that is how you should look at privacy or data privacy in an organization. Moving on. What do we have as a law, therefore, today in the country? There is no exclusive legislation. There is one which is in the making, which is the Personal Data Protection Bill. Again, as I told you, we have been working with the makers of the bill quite extensively. We have attended almost every consultation meet that has happened in the country. We have put forth our views. We have assisted several of our clients in putting forth their inputs to the committee, Justice Sri Krishna committee, to the MeitY, so on and so forth. But point is that before we jump into that, let's understand what we have as a law today and maybe why it didn't work. So, right to privacy has become a fundamental right, and the legislations that are there that are safeguarding data privacy and protection is a patchwork of laws, really. Most important of this is the Information Technology Act, and there is a set of rules which is called the Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011. In short, let's call it either SPDI rules or privacy rules, but that is what we have on a sector neutral basis in order to safeguard data privacy and protection. Of course, there are other legislations like your Indian Penal Code, your Contract Act, Consumer Protection Act, so on and so forth, which assist in a patchwork manner to aid the subject of data privacy and protection. Apart from that, there are sectoral regulations which are there. Sectoral regulators such as Reserve Bank of India giving its diktat to banks and NBFCs, IRDAI giving its diktat to insurance players, so on and so forth. Coming to some of the specific provisions of the Information Technology Act which we should be mindful of. The first section is section 43A. 43A deals with sensitive personal data or information, and you need to have reasonable security practices and procedures in case you are handling sensitive personal data. And if there is wrongful gain or wrongful loss caused, then damages are payable by way of compensation. So this has been there forever. I don't know how many of you would be aware of it. There is another section which we'll talk about, but before that, let's understand what is sensitive data today under Indian laws. So these are the elements which you need to be careful about in an organization when we are talking about sensitive personal data. Password, biometric information, sexual orientation, physical, physiological, health conditions, medical records and history, financial information such as bank account or credit card or debit card or other payment instrument details. Now, it so happens when we are doing, say, a due diligence on a small company, more often you will see organization being a little guarded and evasive in saying that, sorry, we are a very simple small company, we are not handling any sensitive data. And then we start looking into the company and we realize that, there is biometric at the gate. And maybe the HR is keeping a lot of medical data because of health insurance, so on and so forth. So basically, unknowingly, there is housing of sensitive personal data which the organization and its people are unaware of. Coming back to the subject, in order to become a sensitive personal data, the most important part is it has to be personal data first. So thumb rule is if it is anonymized data, it is outside the purview of this law, it's largely outside the purview of the upcoming bill, and it is outside the purview of several or most international privacy laws. Very important thing to take note of, especially in the R&D sphere. So in order to become a sensitive personal data, it's very important that it has to be personal data first. And how has personal data been defined in this sensitive personal data rules? It states that information that relates to a natural person which either directly or indirectly in combination with other information available or likely to be available with a body corporate is capable of identifying such a person. So it's critical that it is to understand that this is a broad brush definition. whether it is information available with you or likely to be available with you, and you can put all of that together and identify an individual, Mr. A or Miss X, it makes you fall within the purview of the definition. You would often find that there are retail players who would be asking you a phone number, and basis that they will do your billing and you get going. So you would be thinking that your name has not been provided, so it's absolutely fine. But you could be profiled completely basis your phone number. And in today's world, to put a name to a phone number, it's not too difficult. So if you're an organization doing that, please be mindful that possibly you should be thinking that whether you are falling within the purview of this particular set of rules, and of course in the upcoming law as well. Let's talk a little bit more about the definition of sensitive personal information. This last element that I spoke about, which is financial information, has been in the center of controversy several times. Because the way it is defined, it says that financial information such as bank account or credit card or debit card or other payment instrument details. So there was a school of thought which says that maybe it's just the debit card number or the credit card number and that's about it, there's nothing more. However, there are judicial precedents which have time and again showed that the adjudicating bodies, authorities have defined this in or given it a wider interpretation. Let's take this particular case law, which is a classic one, I believe, Amit Patwardhan versus Bank of Baroda. On the left hand side, you will see this organization, Rude India Chains. Amit Patwardhan was an employee with this particular organization, Rude India Chains, and later on he moved to a competitor organization, Heco Chains, which is on the right hand side. After he left the organization, his earlier employer brought litigation against him, stating that he might be passing on confidential information to the competitor, and in retaliation, Amit Patwardhan went to the adjudicating officer of Maharashtra and stated that his sensitive personal data was taken out by the previous employer. The adjudicating officer went quite in detail to explaining that how banks have a higher threshold of safeguarding sensitive data, and here it was adjudicated that bank account statement is actually sensitive data as per the sensitive personal data rules. Also, which is not a very happy thing to happen to my mind, there was a penalty slapped on the bank, but that was rupees 5,000 only as a token penalty. To my mind, that these instances have paved a way to the situation that we are facing today, that people are not even aware of a law which has been existing, and therefore we are looking forward to now a law which will have massive penalty amounts inscribed into it. But the moot question remains that we should have effective implementation. I think that is where we are faltering. If we are not implementing these laws appropriately, even the upcoming law could face the same fate as these provisions that we already have. So just for your information, section 43A that I just spoke about and the sensitive personal data rules are intended to be scrapped when the new bill comes into effect. So what do we have under these sensitive personal data rules? There are a plethora of things which you need to take care of when you are handling sensitive personal data. And that is, you need to have reasonable security practices and procedures that are set out in the rules. There are disclosure related norms, there are consent related norms, the grievance officer needs to be appointed, collection related norms are set out, transfer related provisions are there, privacy policy, what needs to go into your privacy policy has been set out. And this item, privacy policy, is often the most neglected item we have seen. In fact, let me give you an example of what we faced just before GDPR came into effect. Before the European Union's General Data Protection Regulation was coming into effect on 25th of May, the night before, a gentleman came to my office and said that my boss has sent me, and tomorrow I think there is a European law which is coming into force, which is called GDPR or something. We need to be prepared, and I have got my privacy policy with me. Why don't you make these minimal changes that you require to make in the policy? I will upload it tonight, and tomorrow morning onwards we are GDPR compliant. So I had coffee with him and I explained to him that good that you have realized that there is a compliance requirement, but this is precisely what the law doesn't want you to do. No lip service. There are several instances in the past where organizations have been held liable for violating their own privacy policy. So you have to be utterly careful when you're crafting these privacy policy, or maybe recrafting it when the new bill comes into effect. Let's talk about another section which is a little more draconian, or of which you should be careful about because there is imprisonment provision, which is section 72A of the IT Act, Information Technology Act. This deals with personal information. So this is not sensitive personal information, this is personal information which has got a larger ambit. And if you have obtained such personal information providing services under a lawful contract, then if wrongful loss or wrongful gain is caused and there is disclosure of that information without consent of the person or in breach of lawful contract, then you are liable to be punished with imprisonment for up to 3 years, or there could be fine up to 5 lakh rupees, or both. So with that, we finish off the whole aspect of data privacy and protection on a sector neutral basis as we have today. Now we would move on to the next phase, which is the Personal Data Protection Bill 2019, the way we see it right now and possibly how it could shape up in future. Coming to this second leg of the presentation, which is the Personal Data Protection Bill that is in the making. As you can see, it has been going on from August 2017. The process is on from then. And I'm not walking you through each step, but as I mentioned earlier, we have been following this at every step. We have attended each consultation meet in order to ensure that we are aware of each clause, why it is crafted the way it is crafted. So the entire legislative history is available with us as our wealth of knowledge, and very happy to share some of these. Of course, the entire thing cannot be shared through this session because it is possibly a day-long session which would be required in order to go through the entire bill. So first things first, which organizations are extremely worried about, how soon is this coming into effect, and how much time will we get once it becomes a law? As you are aware, the Joint Parliamentary Committee is presently has taken in inputs from stakeholders. It is supposed to provide its input to the report to the Parliament, and thereafter it would be the bill would be taken for debating in the Parliament. Now, from the time the Parliament passes it to the complete rollout of the law, earlier there was a provision that this should happen within a period of 18 months. That has been removed. Now, there could be two repercussions. Either it could happen faster than 18 months, which would be quite catastrophic for several organizations in India, because the preparedness, we are aware of the GDPR example. It gave 2 years leeway. Even then, the European companies were struggling. So if it is 18 months in India or lesser, I think entities in India would struggle. At the same time, if it is longer, then I think this whole aim of getting a privacy law into place is defeated, because if it is delayed for so long, which is anyways delayed quite a bit, I think we are losing precious time, in short. So let's take an overview of the bill. If I have to talk about the bill, what all are the key features that we should be aware of? It has got extraterritorial jurisdiction. There are key definitions which have been introduced. The scope of sensitive personal data has been expanded. Concepts such as data localization has been brought in. There are aspects in relation to cross-border data transfer. New compliances have been brought into place, such as impact assessment, data protection officers, so on and so forth. There are new data subject rights, like right to be forgotten, data portability, etc. We'll speak about all of this in little detail ahead in this presentation. There are heavy penalties and compensation, quite akin to what you would see in a competition law scenario, or maybe many would like to say that this is aping what is provided in the European Union's General Data Protection Regulation. And of course, finally, we have a designated data protection authority. There is a lot which has been lumbered on this authority, and we will have to see whether it is a workable solution to have such an authority with such massive mammoth powers. Will it be at all possible for them to deliver this massive task? Why has this bill now become a board level discussion? The reason is very simple. Look at the penalties. There are two buckets mainly. One is 15 crore rupees or 4% of total worldwide turnover. The other bucket is 5 crores or 2% of total worldwide turnover. There are imprisonment provisions. Earlier it was for several counts, I believe 8 counts. Now it has come down to a single count where if someone is trying to bring back anonymized data into identifiable data format and identifying the individual, in that case there would be imprisonment. And finally, there is also compensation provisions which are there. So quite a bit, and if this is implemented rigorously, it could be quite challenging for entities. Let's talk a bit about the definitions. Now, the idea is not to read through definitions, but to pinpoint few critical areas in the definitions of which are there in the bill. If you see, we have in the bill, we have not talked about data controller or data subject. The way these have been defined is data fiduciary and data principal. So there is a relationship of trust which has been brought about rather than what we usually would be seeing in international legislations. Apart from that, there are in the latest version of the bill, there have been some changes in the definition of personal data, and also from the realm of sensitive personal data, the password as a concept has been removed, which of course was creating some confusion, and maybe it's a good thing. Let's talk about the applicability of the bill. So if it is, if processing is taking place in the country, whether it's by state or by any Indian entity, largely it is all covered. If it is a foreign entity, then there are 3 buckets largely. If you are carrying out in any business in India, or if you're carrying out any systematic activity of offering goods or services to data principals in India, or profiling of data principals in India, as in through website, through apps, if you're trying to profile individuals, then this law would be applicable. Now, we have a small observation here. If you see the first bucket here, it talks about business carried out in India. To our mind, I think this needs a better definition, because otherwise, possibly even one-off transactions could fall within the purview of this. Let's talk about grounds of processing. Now, in very simple terms, what are grounds of processing? For example, consent is a ground of processing. Today, I think largely the way Indian legislation is, consent is king. So if you have taken appropriate consent, that's a good ground of processing personal data. But we have seen several situations where, because this is a ground for processing, if there has been improper documentation in an employer-employee scenario and there is an internal investigation happening, in a very strict sense, sometimes you would have to go to that employee, the erring employee, and take consent in order to look into the system of the person. Now, that has created confusion in the past quite a bit. So I think it's a happy situation now. Employment is, for example, a ground for processing. What happens in such a scenario? In such a scenario, of course, you should try and get consent from an employee, but if there are situations where it is not possible, and in those enumerated scenarios, if you are going ahead and processing the information of the employee, it should be fine. Similarly, there are few others, as you can see in the slide, which are also valid grounds of processing. Let's hop on to this set of sensitive personal data. So on the left hand side, you see what is there today under the sensitive personal data rules as a set of sensitive data. Okay. On the right hand side is the larger list which is under the bill, which is the new list or the upcoming list of sensitive personal data, and you have elements such as official identifiers also there, which would be your PAN, Aadhaar, etc. So this list one has to be careful about, because this has to be treated quite differently. And if the present set of the present law is to come into effect the way it is today, when you are talking about data localization, you need to ensure that this set of sensitive personal data is housed in the country, is stored in the country. It can, of course, be sent for processing under certain circumstances, but largely the sifting through of personal and sensitive personal data would be required, and you need to ensure that these data sets are, within the country, stored in the country. Coming to another important pillar of data principal rights. I think for any organization, this is an extremely critical element because you have to prepare for this. The weapon here is in the hands of the individual, or to put it more positively, the right is in the hands of the individual, and these are the rights really. Right to confirmation and access, which I think is self-explanatory. Right to be forgotten, I'll speak a little more on this one. Right to data portability, right to correction and erasure. Right to be forgotten, I think we should talk a little bit about this because it's close to my heart, because we deliberated quite with the Justice Sri Krishna committee when it was getting crafted. And the way we looked at right to be forgotten is quite different from how the world looks at it. Right to be forgotten in most of the laws or jurisdictions would be right to delete everything to the last dot. In a tech environment, practically speaking, one would know that this is quite a challenge or quite an impossibility. But what is the menace that you are trying to really curb is possibly right against further disclosure or dissemination. And that is how it has been crafted in the 2018 version of the bill, and right to be forgotten. And there was no right to erasure. However, of course, in the 2019 version of the bill, there is a new addition of right of erasure which has been brought in. Let's talk about data portability. Data portability as a concept is gaining traction internationally. Very simply put, how do we understand this? Suppose you go to insurance company A, you are trying to take an insurance policy, you would have to give your, say, PAN, bank statement, etc., and then you go to company B, you have to provide those same information again. You could have a situation, however, where this entity A, insurance company A to which you went, provides all this data in a machine readable portable format which can move easily from A to B. And that is what we are aiming at. That's where we are headed. Mostly from the GDPR experience, what we observe is large players are moving towards a dashboard kind of a solution where you would see that data subjects can go log in and they can confirm, delete, change information, and you are done. So there's very little or zero human interface, but there is also a bit of learning on this front from GDPR. GDPR, I guess, is 1.5 years plus ahead of us, so we have a lot of learnings, which I think is a very positive thing. So there have been instances of data thefts through these dashboards also. What we need to ensure is that if in India we are implementing such a dashboard system, I think we should have good safeguards in place where the individual who is able to access the data is able to do it only after due authentication or rigorous authentication. Next, I want to talk about some of the compliances. I think most of these are kind of self-explanatory, and maybe this will require a separate session in order to deep dive into. But if you see the slide, the ones which are appearing with an asterisk are applicable to significant data fiduciaries, that is data fiduciaries which are doing large amount of processing of personal data or sensitive personal data, so on and so forth. So that this is applicable to them. For the remaining, I think we should touch a bit on breach notification, because breach notification again is completely differently handled in this bill as compared to several other legislations across the globe. So the way breach notification has been handled in the bill is quite different from how it has been handled in several laws across jurisdictions, and there is a reason behind it. When this was getting deliberated, there was a thought process that within 72 hours, say, there is a possibility that you would hardly get to know what has happened really, or whether at all personal data has been impacted. Therefore, if you look at the bill today, it is an extremely graded approach to the issue of data breach. If there is a breach which has occurred, you need to go to the authorities. There are certain details which are to be provided, that can be provided, at one go in a stage-wise manner, so on and so forth. And thereafter, a decision would be taken whether you need to go out to the world and talk about the breach and announce it, or you need to gather more information, or possibly, if it is so drastic that you have to put it up maybe on your website, or the authority can also put it up on their website. So if you look at the entire scheme, the way it has been crafted, it is extremely business friendly, and also I would say practical in nature, because there could be a possibility where maybe personal data is not impacted at all in a breach scenario. And if you have, in a rush of say meeting a 72-hour deadline, gone ahead and announced to the world, you could be doing irreparable harm to your business. With that, we go into the hot debated topic of data localization. In very simple terms, it is housing of the data within the country, and there are several theories which are there to this. There is a trade theory, which is basically my data, my oil, and therefore I should be using it the way I am using it. I want to use it. Or there could be security theory, that this is a country's data and it should be accessible to our authorities whenever they want it, so on and so forth. So let's first talk about what was there in the previous version of this particular bill. In the previous version, broadly speaking, there were 4 categories. The first one was a very small, minuscule category of exempted personal data, which could have easily flown outside the country without any requirement of mirror copy being kept in the country, or serving copy being kept in the country. But this was only if it is exempted by central government, or there is under necessity or strategic interest now. The second one is on personal data, which is a bucket, which is a larger bucket, and if that has to go outside the country, then necessarily a serving copy has to be there within the country. The third bucket is sensitive personal data, which if it has to go outside the country, again, serving copy has to be there. And the last bucket is critical personal data, which per se cannot leave the country, but with a very, very minuscule possibility under stringent conditions it could be. Point is, so here critical personal data has not been defined, what all elements go into it, and it still continues to be that way, creating a lot of confusion, a lot of anxiety in the minds of organization. Moving on, what do we have today as a concept of data localization? So, I think in the 2019 bill, the way it is presently, personal data can freely go outside the country. Sensitive personal data can only go outside the country, provided it is stored. It has to be stored in the country, but it can be sent outside for processing. Critical personal data, I think the situation remains quite the same, like we discussed. So that is broadly where we are in terms of the bill. Of course, I've just picked up few snippets which is say most critical or worth discussing in this short session. To wrap it up, I think I would like to talk about few essential tips for organizations. Of course, I think there is a requirement of investment in a tech stack. Seek qualified legal advice because the fines are substantial. You have to change your market practices through, say, explicit opt-ins. You'll have to review the sign-up forms, privacy notices, policies, and you need, as I told you, no pre-selected boxes, no silence is consent. You have to re-vet all third-party and partner contracts as far as data is concerned. Okay, you have to give your IT and legal department a seat in the tables which are determining business strategies, because somewhere, I think, as I told you, privacy has to be put in the center of things as you move ahead. This is my last slide. On the right-hand side is the 5 Ps of privacy, as I love to call them. The first one is information providers agreement, which should be comprehensive. The privacy policy needs to be recrafted and up to date. Procedures for information security have to be robust. There should be proactive monitoring and purge or delete the unnecessary. In a cyclical manner, if you see, what has to be done is identify risk areas, update policies and procedures, upgrade your safeguards and have a constant monitoring facility, have regular trainings. This is very critical because demonstrating compliance is becoming a very big thing in several laws across the globe, including ours. So in a bad day, it is possible that you would have done everything, but even then things could go wrong. So you have to demonstrate that you have done everything, you have trained your people, you have all the safeguards in place, and even then if something has gone wrong, perhaps the rigor of the law would come down quite a bit. You need to have hotlines for reporting of breaches, etc., quick and systematic approach to data breaches, and then again you go back to your cycle of identifying risk areas. So that in a nutshell, ladies and gentlemen, is data privacy protection, what we have today and what we are looking forward to. Any questions, please feel free to write to me. Thank you.